everybody. Thanks for joining us today. I hope everybody is enjoying the day so far. We've got a lot of folks signed up. We had some folks reach out to us in advance, ask us about the recording, and we can circulate that after this is over. And if you have questions, please drop them in the chat box. We've been working on a different platform, and we're getting used to this, a new platform this year. So we like it, but it's a little bit different. So we'll try to keep up with your questions. If we don't hit something during the seminar, please feel free to reach out by phone or email after the seminar and shoot us a question then. My name is Eric Boughman. I am joined by my partner, Gary Forster. That's us there on the screen. And good topic for today. We're talking about asset protection for the single person. We're going to point out a couple times. A lot of these principles will apply, obviously, for people who are not single, but we will call out some specific circumstances that are unique to single folks, and we'll talk about some ways to approach that and workarounds. Here's the agenda for everybody who wants to follow along. You should have some note slides that are available to you as well. And off we go into, we've got a lot to talk about, and so we want to make it as valuable as possible. Also, keep in mind, if you need continuing education credit, please contact us afterwards so we can make arrangements to provide that for you. All right, so talking about asset protection, what we're really talking about here is trying to plan ahead to avoid exposure to creditor claims that come later, again, after a plan is implemented. We're not talking about hiding assets or any type of fraudulent activity, avoiding legitimate claims where you already have exposed assets. We're not talking about any type of unethical or illegal behavior here. We're using existing laws, including certain statutory exemptions at the federal and state level, and titling entities, trusts, and mechanisms that are perfectly legal to be used, particularly, again, in advance when the skies are sunny like today, to insulate business owners and entrepreneurs, and in this case, single people, from financial risk and creditor risk. Gary, anything else to add on that?
Yeah, so I think what the kind of story of this seminar is that over the course of 400 or 500 years, many protections developed associated with marriage. So what would happen would be that dowry would be paid, or an arrangement would be made, depending on which country you were from. And we're in the English format. So in the English format, a dowry would be paid, but in order to protect the dowry, after, and also the marital assets after marriage, this idea of joint titling came into play, where the husband was not permitted to sell marital assets without a sign-off by wife. The in many ways unintended consequences of that was that if someone were to try to reach assets of husband or wife without having a claim against both, the defendant, one spouse, had no right to move the assets out to pay for the judgment. And that developed into this idea of tenancy by the entirety. And as we pulled up here on this this intro slide at number C, you get what's called the basics of titling. And one of the basics of titling is tenancy by the entirety. You've got a number of options, obviously. If you've got more than one person, you've got joint tenants in common, but the protective one is tenancy by the entirety. And that's the idea of, as wife's family pays the dowry, they acquire assets depending on the families, they who contributes what, but the couple owns the assets together. And that really provides the basis of a lot of asset protection in many US states. Now, many US states in the Midwest and West do not allow, either for personal property or real estate, tenancy by the entirety. And those states are actually typically the least attractive from an asset protection standpoint, which is why we came up with this idea, because we see it all the time, asset protection for the single person. And over the years, we've kind of, Eric's defended these, and we plan with these we know what the options are. The options are less if you're single, but there are options, and it's kind of become more clear over the years which options will work, which options won't, what the courts will go for. The nice thing about the entireties is that, there were other reasons for the entireties apart from asset protection. People just naturally, like in Florida, there's an assumption if you buy your home with your spouse that you own it by the entireties. You own it together jointly, and you get all these protections. So there's a lot of value from a protective standpoint in the entireties, which you can't get as a single individual, and you'll see that permeate throughout the 50 minutes.
And while we're not going to talk about titling as tenants by entireties, it is, to me, one of the most subject to the biggest misconceptions, I think, among non-lawyers. I was on a call just last week with a CPA, and I kept trying, and some clients, and we kept trying to correct him to use the proper terminology. He kept saying, "Oh yeah, we'll do it as joint tenants." No, not joint tenants, tenants by entireties. So the different marital entity that you don't have as a single person is the advantage if you have it available. So when we talk about the evolution of asset protection, entities come to mind. Corporations traditionally, and then we've moved into these to limited liability companies, which are common use now. I think the most registered entity now is a limited liability company. But relatively new when you look at the time frame of the development of corporations, which were initially intended so that when you were going to do business, you could do so as a separate legal entity and not expose your personal assets to your business to business risk. And corporations still work for that purpose. The problem with corporations is that if you have shares in a corporation and you individually are subject to a claim by a creditor, those shares in the corporation, your stock, can be seized and foreclosed upon and taken from you, whether it's a small, closely held company or whether you own shares in a publicly traded company like NVIDIA or Apple, which right now are doing fantastically, especially NVIDIA. You can't buy cars, but microchip companies are doing great. But that type of asset is something that can be taken. Limited liability companies came about as really an amalgam of partnerships and corporations. In partnerships, the old law said that you couldn't take a partnership interest. If you were a creditor, you could only get a charging order. And the point behind that was to protect the innocent partner in circumstances such as if Gary goes out this weekend and gets in a drunken bar fight and gets sued. If we had a traditional partnership, we don't want I don't want somebody to sue Gary, take all of his assets, and suddenly Monday morning the alleged victim shows up and says, "Hey Eric, how you doing? I'm your new partner." So you can't take the partnership interest. You can only get an interest on distributions.
So it's a hybrid, speaking of cars. And so it's a hybrid entity.
The limited liability company combined those protections traditionally, and the insulation of the corporation and the charging order protection of the partnership, the traditional partnership.
So you're protected both from liabilities that occur inside the business, and your equity in the business is protected to a degree that it can only be liened. I guess it's the next slide, but probably. Yeah, there you go. Charging order protected. That's the lien. So if you have a corporation, it's exposed. It's exposed. I even at this point, we're amazed at the number of people that don't really understand this. So it's totally exposed. You can do a classic shareholders agreement where there's a buyout in the event that someone's equity becomes exposed. The other partner can buy them out, but that can be cumbersome as well, and it might not work, and the valuation can be wrong, etc. With the LLC, there's no ability to actually take the voting interest, which is very valuable, not just really from an asset protection standpoint, but that's really like a business protection standpoint. So we're really kind of moving to the LLC. If we haven't really moved there completely, there's really very little reason to not have that protection, that charging order protection. But as you'll see in the slides, now we're starting to expose it a little with respect to the single member LLC.
Yeah, so when we come back, the reason we spent some time talking about TBE in the beginning, tenants by entireties, is oftentimes people set up entities to hold interest in a small business that might be operated by the husband and wife, maybe to hold financial accounts or other assets such as passive investment, real estate and other property. And if you title, while this is probably, I don't think there's been a definitive decision on this. The general consensus among people who practice in this area all the time is that tenants by entireties ownership is going to be considered like a multi-member LLC. And so when you have the erosions that have occurred with the single member LLC in Florida, we can foreclose on a single member interest like a corporation now. When you have those types of protections that have been eroded, again, if you're single, you've got a challenge. If you set up an LLC and you're doing it by yourself, you've got to make sure you don't fall subject to
even if the entireties, if a husband and wife own the LLC and it's not considered a multi-member LLC, it's still entireties.
That's right. So you still have to get a claim against both.
It's still got to be a joint claim, right?
And actually, there's some advantages there. So either way, having if being single puts you at a challenge to create. And so we talk about entities because you're still going to use entities as a single person, but you've got to think through these issues, particularly the single member issue.
And we're going to talk about some cases where it's taken years before anyone's even looked at this issue in terms of, you know, what will be deemed a single member. Obviously, if it's a single member, it's a single member. But you know, whether husband and wife could be deemed a single member, whether giving 1% to a child's trust doesn't count. We've been looking for these cases for years, and we're going to go through a few, but you typically come up in egregious situations, and not for planning. But keep an eye on those cases, because that's going to give you an insight into how far you can go. I know we have a lot of CPAs and lawyers on the line. How far you can go in terms of creating that second member, that necessary second member to avoid single member status. We're getting a little ahead of ourselves, but it's kind of the topic.
Yeah, we'll flow into that. And so keep in mind with the LLC that where you form the LLC makes a big can make a big difference on the protections that are available. It certainly makes a big difference on the arguments that will be available for protection, which oftentimes are really the heart of the matter. We don't see a lot of reported decisions on these. Most cases settle, and as long thinking from the way to look at it from a lawyer who has argued over these issues, if you can create the potential for a future argument, it gives you leverage in settlement negotiations. So even though we may not be sure of what the ultimate decision, and we'll see as we look at some of the cases, we'll get decisions that are completely in conflict with each other from one state to the next, and then we'll get California that's like Mars sometimes. But at least by having the arguments available, for instance, you know, if you create a single member LLC in Delaware where you apply Delaware law or Florida law, well, that's
an argument.
It's an argument,
and it causes the other side more expense, which is
doubt and leverage. So we'll jump into and of course we've got that argument. That's the internal affairs doctrine.
That's what, you know, that you should use the law of the jurisdiction chosen in general.
So do we have? I want to make sure we cover that. If we can jump into structuring, so let's cover that issue a little bit and talk about that, because I don't think we have that case in here today. There's a couple cases we've talked about in other seminars that we've done. There's a case involving Wells Fargo, and
there's a mention, I think.
Is there one in here? Yeah. So the question comes up: if I am an individual in Florida and I form a Delaware LLC or a Nevada LLC, which specifically both those jurisdictions protect by statute the LLC single member interest, where Florida has in its statute that if you have a judgment against an individual and it's a single member LLC, if you can reasonably show that you're not going to get paid through the charging order, you can move to foreclose on that interest. If you're in Florida and you're a Florida creditor and you sue an individual in Florida who has a Delaware LLC, can you foreclose on the interest because Florida allows foreclosure? If you ask Gary, he'll tell you that well, this is the argument, and this is the argument we make. So the internal affairs doctrine says what about that Delaware LLC interest?
Well, the internal affairs doctrine, for whatever reason, is kept quite general. But the idea is that if an entity is basically rules protecting the box. So if the box is created in Delaware, the rules are under the Delaware statute, and the internal affairs doctrine suggests that, if you choose Delaware, the Delaware law applies. I mean, that's kind of the way it should work. And then you get into these egregious situations where someone, has a claim against Delaware LLC operating in Florida, and it's a good claim. They win the judgment and they say, I won, you crashed into me, I want your Delaware LLC. We're in Florida. And, the reason Eric says what I say, and he said, is because, you can debate this thing, but if the plaintiff in Florida who wins the judgment against someone with a Delaware LLC says, look, we're in Florida, you're doing business in Florida, everything you have in Florida, Florida, you're come on, you can't just pick Delaware. And so you're going to see in some of these cases that we see, if you're a defendant and you've just gone too far, you're like hiding things and running away from people all over the earth, you're probably going to lose. But at what point is that argument clear, where if you pick Delaware, which says, okay, if you have a single member LLC, it may not be taken from you. At what point is that clear? We don't know at what point's that clear. The reason that Eric and I have these debates is that, the law says if I pick Delaware, it's Delaware. It's Delaware, and Florida says we'll respect the laws of other jurisdictions. So that's why it's kind of a tough topic.
Yeah, and there are cases that are reported on both sides of this that have come down both directions, and oftentimes it does, as Gary alluded to it, it depends on the actions of the bad guy. Depends on if there's a debtor and the debtor's hiding stuff. We saw one case, the Barber v. Wells Fargo case. I think that's in our materials, but if anybody wants that, send us.
It's there's a reference.
There is. Okay, so in Barber, there was a judgment against an individual. She sold property, moved money through 2 or 3 or 4 different bank accounts, had a Nevis.
Well, she defaulted.
Right, she was on a $67 million debt. The
She's
creditor showed the court that they weren't going to collect on their charging order. $67 million.
Yeah, well, she starts scrambling.
She was moving assets, engaging in what appeared to be clear fraudulent transfers, and that would have been a remedy. Fraudulent transfer.
I think that was the case. It's a fraudulent transfer.
But the federal court that I think it was a federal court here that
it was in Florida.
It was the Middle District Florida court said, I don't care about your Nevis LLC. You are here in Florida. You're in my courtroom, and so the interest is in my courtroom. And I am going to treat that interest like a single member interest here in Florida. So if you have a statute that says you only have a right to a charging order, like the Delaware statute, or you have a statute in Florida that says that you can foreclose on a single member interest, which one do you apply? And if you're the creditor and you're in Florida and something bad happened, let's say I was out and I just let's say I'm the victim in a drunken bar fight.
It's a fairness.
Yeah, I say, well, look, I didn't agree to Delaware. You set up Delaware, but you've got the property here. That's fine. The applying Delaware law is great for your operating agreement, you and any other members and everybody you're doing business with internally. But as to me, I'm going to ask the court to apply local law.
That's right. The problem is on that argument is the court actually has to go and transform the Delaware box into a Florida box. And it's for the corporate tax international, it's like very tough to deal with that. But for litigation, if it's an argument, you're exposed. So you abuse in these LLCs and trusts is just not recommended. On many cases they won't hold up. You'll see in a few cases in bankruptcy they almost never hold up. But if you use them properly for planning, they can be very, very effective.
So we got a question. It says, why not just get an umbrella policy? You can. By all means. I'm a proponent of lots of insurance. We use insurance, but
But that's not,
insurance
but that
covers
doesn't
you.
solve that problem.
that's a totally different issue. Can be used hand in hand.
So if you were Sabrina Barber, but you were sane, by the way, there's other aspects of that case involving homestead, so they're completely mishandled. So an umbrella policy is, okay, I got in a car accident, right? But what if you were Sabrina Barber? What if you borrowed a lot of money? Maybe you had a lot of money and you had a loan guarantee and you did your estate and your asset protection plan, you let the bank know, and 5 or 6 years later, you ran into unforeseen problems. Well, an umbrella policy is not going to do anything for you with respect to a loan default, but the asset protection likely will.
And the two combined, let's just stay with the drunken bar fight example and say somebody claims damages of $2 million, and your umbrella policy will cover you, but you've got $1 million in coverage.
Maybe.
Yeah, let me restate that. I'm not saying the umbrella policy will cover you. I would have doubts about that. But let's just say you're in your driveway and a neighbor attacks you in a drunken bar fight and you smash his head into the concrete using your fancy judo skills. I'm just using ridiculous examples. Actually, I know a situation where this kind of happened, and there's an injury and a claim. Well, if you've got your insurance that covers, but if the claim is far in excess of the insurance, you walk into the mediation. It's a great situation. You say, look, Mr. Claimant, here, you got some insurance money right here. You're going to get paid what the insurance money companies put money on the table. Let's resolve this suit now, pre-suit.
Nothing else is going to be available.
But if you keep suing, all that's going to happen, it's going to take more time, more resources. Your lawyer's going to keep going.
You've got all these arguments and structures. Yeah, that's
you're not going to get to
it's a combined approach. And even with the doctors, we say it's a combined approach. You always want to have that available, that insurance, but it doesn't. Insurance, the first thing that's going to happen, excuse me to your property and casualty people out there, my dad was one. If there's any exotic aspect to the claim, you're going to get a denial. It's going to take a while. It's going to be an undervalued claim, etc. However, that being said, it's great to have insurance. Also, usually it's very inexpensive to have insurance. And then you want to do all of these structuring moves. Now, many of these structuring moves require very little in exchange. Some high-end exotic moves require giving up control. Maybe there's some issues with respect to gifting to the family. But a lot of this stuff is really kind of a no-brainer. You really don't give up much control of the asset, yet you require some substantial, protection.
This is great. We got more questions. Keep them coming on the questions. In Florida, can you have a single member LLC for a husband and wife owned rental property? I'm not sure why you would. I think if you had rental property, you would want to own that LLC interest as husband and wife tenants by the entireties. It's a good idea to put the rental property, which is something that creates liability, slip and fall, all kinds of bad stuff. You could rent to a tenant who has a dog that bites the mailman and the mailman sues you. These are all like real life examples where I'm changing the names of the creatures involved to protect the innocent. But if you have rental property in your own name, you really need to get it out of your name. It's exposed to creditors and it exposes you to issues. You should have insurance on it. And if you are husband and wife who own the rental property, or if one spouse does, it's a good idea, I think, to first thing we should look at is a LLC that owns the rental property, and the LLC interest is owned by husband and wife as tenants by entirety.
Definitely. And if the intent is to acquire a number of properties, we want to segregate those properties in different LLCs. And those different LLCs can be held by a holding company LLC, a protective LLC, as husband and wife if you're married. If not a single member, we'll get to the different pieces. You'd add members, but a holding company owning an LLC that owns each property. You segregate the liabilities for each property in each subsidiary LLC, and you have a holding company that consolidates the group for one tax return with a protective LLC on top.
And the creditors can't get into the individual to the individual LLCs that are the subsidiaries, because if they're coming through you, they have to go through that holding company.
Right.
Yeah, that's the best way to really look at start doing that. So we talked about, you know, where to form the LLC, and particularly this becomes a question that you really need to focus on from an asset protection standpoint if you are forming as a single member. And so you want to, we talked about some of the arguments that could be raised. And although there may be some uncertainty as to the arguments, we pretty much know that if you use a single member in Florida, you're going to lose. You're going to lose that interest if you have a claim. So let's go to a jurisdiction that provides statutory protection for the single member LLC. And so that's our first point here in this next topic on structuring the single member LLC for asset protection. And so we've mentioned Delaware and Nevada. Lots of folks used to use Wyoming. That was popular because Wyoming was it was a real popular LLC jurisdiction back in the early 2000s. The problem with Wyoming is the exact opposite issue of the protection of the single member LLC. Is that Wyoming, a subsidiary company that had a parent company, so that same parent subsidiary relationship Gary described where you own property. In Wyoming, the problem there was that this subsidiary had a lawsuit and was sued, and the court, the argument was made to pierce the corporate veil of the subsidiary to reach the assets of the parent. Very tough to do in Delaware, very tough to do in Florida. Basically, they follow the same legal standard.
Yeah, it was pretty hard to do in Wyoming. What was shocking, the reason we bring up the case is, you know, Wyoming was the first state with an LLC. So Wyoming was a huge advocate of the protections associated with LLCs. And then you get this wild ruling by a court in Wyoming that the subsidiary could be pierced up to the parent. And what happens is, like when I mentioned the properties, you have the holding company and below are the subsidiary. If you can get up into the holding company, then you're done. Then everything's a single member LLC. You can get down, or subsidiary, or whatever. I think they had corps here, down into all the assets. It's like a disaster. There was like a sucking sound for people leaving Wyoming at that point. No one uses Wyoming anymore because the message was that the courts weren't on board with respect to this. The internet.
A lot of people come in. If you do an LLC on legal Zoom.
Oh yeah, and that's not a great.
Don't use Wyoming.
That's because it's very
now. I haven't looked at the Green Hunter case recently to see if it's been overturned or any appeals on Green Hunter. I mean, nobody bothered. There was really no reason to go to Wyoming other than the original popularity. And when this happened,
it was inexpensive. Yeah, this just destroyed this thing. Oh, I know it did.
So it's really Delaware and Nevada. I used to practice in Nevada. I like it out there. It's good. It's very protective. It's probably, I think, just the and I'm still licensed in Nevada.
Nevada's a great, and we're going to mention the trust. Nevada's a great trust jurisdiction too. The reason we still do a lot of Delaware is because it's totally anonymous, which is just a convenience. It's very people file these things and they don't want it to be so easy to look them up. And Delaware is still completely anonymous.
Yeah, and Nevada, you have a little bit. You have to list a manager. Yeah, it's a good climate generally. You can also, we're going to get into the self-settled trusts. Nevada is a great jurisdiction for that. While we're talking about LLC, protected jurisdictions, offshore LLCs, I'll let Gary speak to that. He's written part of that NEBIS LLC statute.
Yeah, if it's appropriate, a lot of times we put an offshore LLC under a foreign trust, and we're going to hit on foreign trusts in a minute here. A lot of times the clients come in and want kind of a bomb shelter where they've sold their business and there's an open, for instance, an open indemnity claim, or they're in a highly risky business. Is it, well, I'd like to do a foreign trust with a foreign trustee and a Swiss bank account or a Swiss investment account, diversify what I have in the States. They go through it's a whole process. But the key to these entities is that the U.S. court has no jurisdiction over the trustee, the assets, or the entity. And it's very hard to reach into these entities. Eric mentioned the Nevis LLC, which I had a hand in writing the fraudulent transfer side of that statute. It's kind of an American style LLC, which is very convenient to use. And then a lot of these issues of exposure were eliminated in terms of someone reaching the asset, like this bond requirement. We have a little list here. This the fraudulent transfer, statute of limitations, and the expiration of the charging order.
And so next point that we make, besides the importance of choosing the right jurisdiction, is try to avoid, when possible, using a single member LLC. People can do this. One common method that we recommend is using a traditional trust, or a recognized asset protection trust as a second member. What about the 1% interest to the child, or the 1% interest to the child through a revocable trust? What are your thoughts on that?
Well, that's a different, well, we wouldn't ever do a 1% interest to a child through a revocable trust. It would be, what's happening is we're avoiding this single member format, and sometimes we can create a trust, an irrevocable solid trust. And if you have 2 kids, you can just do a trust for each kid. We really kind of have gotten away from this 1% thing, because it's just going to be a matter of time before, actually, we have a case that suggests that you can't do it. Before they say, you know what, 1% is really not going to work. So we try to get it to at least 5% to each irrevocable trust with another trustee. So the founder of the LLC and the trusts would not be the trustee of the trust. So we try to kind of diversify the ownership a little bit, and it's very likely that's going to work, because it also works for estate planning purposes. So as we get into trust, the story with respect to the single member, the single person, is, okay, we've got the LLC. Now we've gotten that far. We know we're going to do an LLC. We're going to segregate assets. We're going to separate properties, etc. We know we're going to add people. We're going to add trust for the kids. We're going to, if we don't have kids, we're going to figure out somebody who wants to buy in, or something similar to that. Now we've got the single person client. Even the LLC, if you're sued and you have an LLC, it can be liened. That's that charging order lien, which is not pleasant. I mean, typically it leads to negotiation, because although it's a lien, really the plaintiff, judgment holder, has to be delegated a distribution. That membership interest has to receive a distribution before a lien holder gets anything at all. And a lot of times the client defendant says, I'm not going to make any distributions. You're going to have to wait. So it does spur settlement. There's no doubt about that. But what about the lien? The lien is not very attractive. There's only a few ways to get rid of the lien, and typically a U.S. client, single person, doesn't want to go offshore. And the reality is, if the assets are onshore, like for instance properties, are onshore, offshore planning is dicey. So what you have left now, you have 18 states that offer a self-settled asset protection trust. So those rules regarding trust over the last 500 years, they don't protect a founder's assets if put in a trust for the founder, the settlor. So in the late 80s, early 90s, you had a lot of offshore jurisdictions saying, we're going to change that. We want you to put money into these trusts, because we want the filing fees in our jurisdiction, and we're going to create the law ourselves. And it's going to say, look, you can put it in yourself as long as you have a trustee on the island or wherever you're at. It's protected. It's protected, and it's our law. So you had a lot of money going offshore, or a lot of money at least going through these foreign trusts. And then we had Alaska, Delaware, Nevada start the same process. No one knew how it was going to go. We're now a decade into that, and we kind of know how it's going to go. But an option is for the single person with this multi-member LLC who's subject to the lien, put it in a domestic self-settled trust. Do we know it's going to work for sure? Well, we think it's usually going to work if we set it up correctly for a person who is not running from creditors, who doesn't go into bankruptcy. What are the options? They're pretty limited. They're pretty limited. So it's a good idea, kind of, in any case. We haven't had no administrative or technical problems with it ever. And Eric has defended a handful of them based on jurisdictional issues. They're for real. The statute's for real.
Yeah. The Nevada trustee for a Nevada type trust, and the trustee, the part of the creditor may try to sue the trustee here in Florida. We object in jurisdiction. The trustees aren't coming to Florida.
Right.
They don't come to Florida. They don't have jurisdiction. They're not subject to jurisdiction in Florida. And we've had that argument.
And it kind of forces the venue into a favorable court in the home field. That's what happened with that woman, Sabrina Barber in Florida. She was arguing about Nevis in Florida. So, Florida, Nevis, where's Nevis? And they threw it out. But when you move Nevada trust into Nevada, oh, your odds just changed. Your whole negotiating position just changed.
And we could go on the Barber, had she had LLC certificates, put them in the possession of the manager in Nevis, it may have changed that whole case, but we don't know. So here's another. So a lot of times we'll get folks that have the LLC, they don't want to do the self-settled trust to put the interest in or for part of the interest. They don't have a child or anybody they want to add as a second member, so they want to go along with it as a single member LLC. But what happens if you have a single member LLC and the owner or the member of the LLC is now subject to a creditor's claim? That LLC interest is subject to foreclosure because it's a single member. But what if the single member converts to a multi-member? And there is a case on this one here in the materials is Sardis v. Frankel. It was a New York case, as I recall. I don't have the site in there, but if anybody's interested in the case, I do have a copy of it. Yeah, it's a New York case. And in that case, the debtor owned interests in Florida and in New York. And during the case, transferred 10% of the interest in the company to her son. And that seemed, again, sometimes it's not real clear, but it's not an appellate case. I think this was a lower court case. But reading the case, it seemed to work. The court certainly wasn't offended by it. And now you've got a multi-member LLC. And if you're trying to foreclose on a multi-member LLC, you've got the statute in your advantage. So I encourage you, if you're interested in that, to go look at that Sardis v. Frankel case or shoot me an email afterward and I'll get you a copy of it. But it raises the question here, is there a fraudulent transfer concern with an LLC that goes from being a single member to a multi-member LLC in the midst of a claim, in the face of a claim, particularly if the interest isn't just given away, but if somebody buys in, if somebody puts money into the company, makes a contribution of some sort, and if the fair value of the company is determined to be, whatever figure that is, and somebody buys in, and maybe that money's used for litigation expenses, and if you did that, would you have the new member buy directly from the company and buy an interest, or would they buy an interest from the single member? Does it really make a difference? So these are some questions that
it creates kind of a nice complexity.
It does. It creates issue. You're not, and if you don't do it, if you don't do, these are some notes here that Gary and I talked about this before when I saw this case, and we've talked about it, and I tend to think it's not real clear. There's a whole bunch of material in here, but if you get money for the interest and you take that money and you leave it exposed, it's this idea of don't be too greedy. We have a whole seminar we do on this. Don't be greedy. Don't take the money for the additional interest and try to hide it. Leave it exposed to the creditors. Pay your lawyers with it. In fact, pay your lawyers first with money
Upfront.
and upfront as much as possible, and within a reasonable fee. But pay your professional advisors with the cash, but then leave the cash somewhat exposed. Make the creditor work for it, but don't hide it. So if the creditor complains that, well, you've committed a fraudulent transfer, how do you make that argument if there was reasonably equivalent value exchanged for the membership interest, and the creditor got the benefit of some of that value being exposed to the creditor's claim?
And the issue is that it kind of seems like a transfer to avoid a creditor, but it doesn't really fit the fraudulent transfer statute. So what happens is, on fraudulent transfer, it creates the ability of the plaintiff to unwind the transfer to reach the assets transferred. It's not really a remedy to change how single member LLCs work. You've created the multi-member LLC. The question is, did you receive something not for value in an attempt to, without giving value back, in an attempt to avoid the creditor? Well, no, you gave value back.
And it's like if you have a creditor claim and you've got an expensive automobile, you've got a Rolls Royce that's worth $100,000. If you sell that thing for 80, it's not a fraudulent transfer. If you give it away and try and retitle it in your mom's name or your brother,
That's not good.
That's gonna be a fraudulent transfer. But if you sell it, even if you sell it for less than the fair value, if it's reasonably equivalent value, you don't have a fraudulent transfer. And I tend to think that the same would be true. You don't meet the elements of a fraudulent transfer. So it's something to think about. Let's move on. All right, so we get away from LLCs. We'll talk about what we've already touched on here: domestic asset protection trusts, permitted now in 17 states. I think 16 or 17, 18 now.
Just having Ohio adopt that.
18 states allow self-settled trusts, and no, Florida does not protect the self-settled trust. I have heard from clients that lawyers create self-settled trusts in Florida. That might be so. But if it is challenged by a creditor, it will not work.
Oh, it will not work. It clearly is not allowed in Florida. You can create your own trust, but the assets are not protected from your credit.
They're not protected. You've got a statute on revocable trusts. There's some law out there on the self-settled trust. Revocable trusts, it's a direct look through, again, per statute, the case law, self-settled. Irrevocable trusts still protect, but if you want to set something up for yourself, how do you go about doing that? And Gary and Brian here in our office, they do quite a bit of these. Nevada is really growing in popularity, especially right now. We're seeing a lot of people, I think, got scared during COVID. And
we are seeing a lot of self-settled trusts. We're seeing a lot of all kinds of stuff: pre-immigration, pre-expatriation. People are leaving. All kinds of stuff's going on. But what I had alluded to was, when we have these multi-member LLCs with a single individual forming them, we do get the charging order protection on. We likely get the charging order protection on the equity. But what if we want to stop that lien from being filed, and we do it in a plan, as a planning strategy? You pretty much have to go with one of these self-settled trusts. And when the skies are clear, when you've completely funded your LLC, you might do it as part of a business transaction. You might do it as part of an estate planning strategy. And the single person takes their interest. And what happens is, we remove the lien by saying, okay, the single individual is no longer the legal owner of the equity. It's now a trustee in Nevada, and that the Nevada trustee holds and controls a Nevada trust, and that trust holds the LLC interest. People always say, well, God, I need to keep making my investments. I need to control everything. I need to watch everything. I need to monitor what's going on, either in the business or the investment portfolio. That's not a problem. That's not a problem. the idea is, in a nutshell, the idea is that the Nevada trustee controls distributions. You can replace a Nevada trustee, but the actual titling of the asset of the LLC membership interest is in a Nevada trustee's, company's name, and money cannot come out without the Nevada trustee's approval. The management of the investments is a totally separate issue, but no money can come out. That way, when there's a suit on the client, the actual legal title to that equity is not in the client's name.
Banks will ignore a claim against the individual client, anybody holding possession of any assets that are titled in the name of the trust. They're going to look to the trustee. They're not going to look to the individual.
Absolutely.
And I'm going to tie this back in with our insurance question from earlier. So we said, why not get insurance? It's interesting, I think, sometimes to understand the policy on how some of these laws develop. We talked about the LLC earlier, and just quickly on Nevada and why it's so favored. As I mentioned, I practiced out there in the early 2000s, and at that time I actually knew a couple of doctors, and one guy I was friends with was a pretty well-known doctor there, and they were having a really difficult time getting insurance, malpractice insurance, because lawsuits were crazy. There was a big push there. They can put things in the law according to a vote of the people. They can make amendments to the law, and there was a push for tort reform and limits on punitive damages and lawsuits that failed. And so the trial lawyer lobby won that round of the fight, and there was almost unlimited exposure for judgments in Nevada, and the doctors were kind of freaked out. And it was medical community, and there was worry that a lot of the doctors, they were either getting out of practicing medicine, they weren't carrying insurance, but they could go out of business with one bad claim. Mm-hmm. And there was a big worry that there was going to be a shortage of healthcare available in Nevada. And so the legislature there essentially backdoored protections. They said, okay, we don't have tort reform. You've got these high claims, expensive insurance. But what we're going to do is we're going to allow people to plan and use the self-settled trust here in Nevada. And that's why the statute is so well written there. There's no exceptions in the statute. It's very fast seasoning. And that's why when people say, well, how come you can do it in some places and not others? That was what happened in Nevada in the early 2000s. And other states, they just want maybe the trust business. But that understanding that background lets you know when you go into a court in Nevada, if you're defending jurisdiction here, you get jurisdiction kicked out of the court here because the court recognizes they don't have jurisdiction over a Nevada trustee. Now you got to go make your fight in Nevada. And when you're dealing with that background, there's not a Nevada court. There the judges are elected. And there's no Nevada court that's going to look at that and say, oh yeah, I'm going to let you get to the trust. So we've got a few minutes left where we can field some questions. We can talk about a couple of the cases if you want. We're about 45 minutes in. Which one of these do you like talking about the best? Huber's probably the most applicable.
Huber's applicable because it was a contractor in Washington State that kept all his assets in Washington State. The co-trustee was in Washington State. The protector was in Washington State. All his children were in Washington State. All his, so everything was, and then he formed Alaska Asset Protection Trust, which might have worked, but believe it or not, but then he went bankrupt. So that what happens in bankruptcy is they can use a public policy argument, and if you don't have any connection to the jurisdiction of the trust, that what they say is, you've got 8 billion creditors, you've defaulted, and in bankruptcy, the reason you don't go bankruptcy if you want to protect your assets is the idea is it's a discharge. It's not an asset protection rule. It's that you have all this debt. They'll discharge the debt, but man, those assets get looked at really hard. So what they said was there was no connection between this Huber and the trust, and the public policy will not let us allow for those protections. So that's a good nutshell, isn't it? I thought that was pretty oversight. Mortensen is beyond belief. This was the mountain man, Mortensen, the mountain man, who basically, he did his own trust, which we really don't recommend. It's kind of complicated. He was from Alaska. He had an Alaska trust with an Alaska trustee. he got a divorce after the 4-year, I think it's a 4-year
4-year
statute
limitations.
of limitations on funding. So that what we say about that, the reason we mention that is a lot of times the argument of the plaintiff is to say, look, you funded this protective entity to avoid me, and that's a no-no. You knew I was going to be a creditor. I was a creditor at the time. I get to go reach it. The entity works, but I can unwind it. That's fraudulent transfer. So he was kind of all set. And then he went bankrupt and extended the statute from 4 to 10 years and got destroyed in the divorce. The whole thing was, you got to read if you want it for the lawyers, read the CBS online. It's an amazing kind of story. I think the Bertrand was a technical.
Bertrand was just a technicality, and but it showed, and it was somebody not from Alaska that had an Alaska trust, and it just came down to this affidavit that was required to be filed before the trust was
funded. They do. They have
a
financial affidavit.
There's a similar requirement or there's a similar case rather in Tennessee. We've seen this a couple times. Again, courts may sometimes not like these. And so any technical defect the court might jump on. So you don't want to be if it was a lawyer who drafted that, you want to be the guy who did it. A court who sits through a big trial and 6 or 8 months of litigation, and then there's a judgment, does not want to hear, oh yeah, you've got a great judgment, but you can't get anything on my Alaska trust. So you really have to dot your I's, cross your T's. Here is, so we showed you a couple cases showing the mistakes. The big one is you got to have some connection to the jurisdiction. You at least have to have your trustee in that jurisdiction, and make some other connections. This Trust Co. v. Matthews case, this is an example. If you're doing this is an example of how to do it right. The trust, the debtor had several. It was a guarantor in some commercial loans, and notified the bank, the creditor bank, that she was engaging in some updates to her estate plan. She was creating these trusts, and so they knew ahead of time. She wasn't trying to hide anything. And then she later went into default, and after the default, the argument wasn't over necessarily the enforceability of the trust, but what Gary, you talked about on the last slide, the statute of limitations, the state statute of limitations for funding the trust. Well, there were some complicated issues in the case, and so the court, my impression was the court really didn't want to get too deep into it, and saw that the statute ran, and that was it. The statute ran. You can't have the assets. You're done. Your claim is barred. And so once the statute ran, you had a trust that was enforceable. Yeah, under Delaware law. So, and that was a court looking at a Delaware resident. It was the case, I believe, was in Delaware, if I recall correctly. Yeah, it was a Florida issue, but they didn't move it out of Delaware, which is another mistake by the plaintiff. Yeah, I would have gone after the debtor in Florida and tried to make that very same argument to a Florida court. So a different result. These are the trusts that really the single person might utilize to protect the LLC equity. And then we'll touch on, we've got a couple minutes. We're going to wrap up here. If there's any other questions for us now, but similar to the DAP, the Domestic Asset Protection Trust, we have the foreign trust, which just takes a lot of the same concepts, but puts the trust and the trustee offshore. And Gary does those. They're a little more complicated, but they're kind of like bomb shelter-ish. Yeah, it's the same idea. It comes down to the idea that the court who's hearing the case or the collection of the case won't have jurisdiction over the assets of the trustee. And it becomes a different issue. In other words, the amount of money at issue really has to be substantial at that point before a plaintiff is going to spend the kind of investment to go after something in a foreign trust. It's very protected. We've got a couple cases. Okay, there's Wells Fargo. Yeah, was in here. The Wells Fargo v. Barber case. That was an LLC case, but again, the same principles apply to the trust, where if you have all of your assets, it's kind of like Barber is kind of like Huber, except that occurred in Florida and involved LLCs. Yeah, that's right. So it was a Florida resident who had assets, and actually the main asset was an interest in a bank account. which can be good or bad, but you take a bank account, put it in interest. Once you take the LLC interest, now you
Well, it
control
was
the
in
account.
Florida too.
Yeah.
It was
Everything was in Florida.
Yeah.
So if you had that situation with it, if she had a trust, a Nevis trust instead of a Nevis bank account or Nevis LLC, yeah, the result very well may have been the same. Court may have said, look, I don't care.
Well,
about
yeah, but
fancy
collection
trust.
would have been hard if the asset wasn't here. We wouldn't advocate that, but I think collection would have been hard if
Yeah, she had a Florida bank account.
Yeah.
She had an account at some Florida bank.
They
which
weren't
made it
going to
very
let that
easy.
go. Yeah.
And then the Sargent case
Yeah,
up
the
here.
new
Actually, I've got a
case.
case involving some. I've got a case
But you got the
involving
new case
Massachusetts.
overturning.
Yeah, there's another case that's now questioned some of Sargent. I've always questioned it. It's an older case. It's an interesting story. If you want to hear about Sargent, I think you can find probably a podcast on it. The Wall Street Journal did a little story on it a couple of years ago, talking about that lawsuit and you know the group that's chasing the debtor all around the world, trying to collect from them, chasing them by jet. But the court essentially found there that assets that were located outside of Florida, they didn't have jurisdiction over. That court did in Florida. I think it was a fourth DCA. Said there's no jurisdiction over the assets. You have to go to the jurisdiction.
And that's a certificate on an LLC or corporation. That means you could move the certificate out of Florida, and the court will not force collection.
Isn't that crazy? You get a lot of people do the LLC. They don't certificate the interest. You create the little certificate and you mail it to Nevis. You go visit it once in a while.
Tangible, right?
Now the court says it might be a tangible interest. And you got to go chase the interest. Again, that's in question. I need to do an update on that because I've kind of
it's a
Massachusetts thing that
issue.
we're dealing with that now. Massachusetts is trying to decide if they can exercise jurisdiction over Florida assets. And so I have to answer that question. We're trying my best. And then public policy is always an argument. Here's just a rundown as we wrap up. We're at 12:58. I don't see credit for CPE. We'll have somebody contact you for the CPE credit if you want credit for that.
Yeah, you can get it.
And we'll assist you with applying to the Florida bar. There's a form you can fill out to get credit from the Florida bar for this as well. Here's just a chart for your own purposes there. If you want to compare foreign jurisdictions, I wouldn't dabble on that area, but it gives you a good overview. And some of the same issues that apply to LLCs apply to trust. If you disregard the trust, if you leave excess control with the settlor, if you treat the trust as essentially an alter ego, these are all ways that you can attack any of these structures. And we got keys to effectiveness. And that's it. This is kind of our wrap up. This is kind of what we learned from Huber, what we learned from Barber, what we learned from Mortensen. That's why we talk about these cases that have, sometimes disastrous results for the people who tried to implement some of the strategies. We say, okay, what was good about it, and where did they screw up, and how do we fix it? And the last one there is, we've done a whole seminar called "Don't Do Asset Protection," and obviously we're big fans and think that it's something to do at the right time, but you combine it with other, we call it sort of personal planning. You combine it with estate planning, maybe some corporate structure. Other final advice, tips?
No, I think that was a great seminar. If you have any questions, we're going to show you our contact information. Please, call us or email us. We can get you the program. We can get you. I have a book on asset protection as well, and then a book on the estate and gift tax for the non-citizen. We can get you all those books. Eric did a book on a different technical issue. Eric's got a lot of asset protection and medical regulatory articles. If you have any interest in that, I know we have a number of medical professionals online. We appreciate so much that you attended.
And it's nice. We like we do these webinars on a regular basis. In 2 weeks, we'll be back, or no, next week, next week, we'll be back with asset protection for physicians. There are some, just like with single persons, there's unique issues that come up in medical. I kind of touched on it a little bit. You usually have insurance in play. So we'll touch on that next week. And if anybody is interested in having us come out live, now that things are opening back up, love to do these. This is a lot of fun to do in a live presentation format. We can really field a lot of cool questions and enjoy engaging with the audience. On that, thank you very much for joining us today, and have a great rest of your day. Bye-bye.